Each year, thousands of athletes sustain head and brain injuries while participating in sports. These injuries occur in almost every contact sport, but are most prevalent in sports like football, hockey, and soccer. The CDC reports an average of 283,000 emergency room visits for sports-related head injuries per year just among youth athletes. Who should be held responsible for brain injuries in sports? In many cases, it's just an unfortunate circumstance of the game, but sometimes negligence and tortious action can be to blame. Determining who can be liable for a sports injury can be difficult. Every case is different, with unique factors and situations leading to and following the injury. By understanding potential liability, you can more accurately assess fault and determine responsibility. The following are potential liable parties that you should consider. Below, we'll discuss how different parties can be held liable for sports-related brain injuries. There could be a range of people and groups that could be found at fault for a sports brain injury. Coaches of the player who suffered the injury can be held liable for a brain injury. This instance typically happens when coaches know of a player's previous head injuries and put them in dangerous situations. Coaches can also be held liable for putting an athlete at unnecessary risk without prior warning to the athlete of the assumed risk of the activity. Coaches can also be held liable for brain injuries occurring as a result of blatant disregard for the laws or regulations of the sport. A coach decides to start a player who has been recently diagnosed with a concussion but who has not been cleared to play. The player suffers a second concussion, resulting in a TBI. Companies producing protective equipment for the head, like football or hockey helmets, can be held liable for brain injuries suffered by players. If there are product defects which jeopardize player safety, leading to initial or worsened head injuries, the manufacturer could face legal action. A snow skiing gear manufacturer produces a new helmet that has a subpar impact rating that does not meet regulatory safety standards. A user wearing the product correctly suffers a head injury after crashing. Medical professionals can be held liable for a sports brain injury, specifically in their response to patients. Wrongful diagnosis, misdiagnosis, and medical malpractice are instances which the doctor can face legal action. A doctor misdiagnoses a head injury due to a high dive accident, telling the diver he has suffered a minor concussion and can return to competition in 2 weeks' time. The diver has actually suffered a TBI. During the next event, the high impact of the dive causes the diver to suffer a second TBI, resulting in permanent disability. If another player acts in a malicious manner outside of the scope of expected conduct, they could be held liable for a sports brain injury. This includes any actions taken that would not be deemed appropriate or proportionate to the sport. A field hockey player strikes another player in the back of the head with a field hockey stick after the whistle, causing the player to suffer a serious contusion. During the post-game handshaking line, a basketball player punches an opposing player in the face, knocking the player unconscious and causing brain damage. The athlete who attended a brain injury could be held liable for their own injuries, meaning they do not have the legal avenue to collect compensation for their injuries from another party. If an athlete is injured within the scope of expected injury or as a result of their own decisions, they could be liable for their own injury. A soccer player is told by his primary care physician that he cannot play in an upcoming tournament due to a head injury. When asked by his coach, he says he's cleared to play. The player suffers a secondary injury that results in long-term brain development issues. Evidence is key in sports brain injury lawsuits and critical in determining liability. Sufficient evidence to collect in a sports brain injury claim would be medical bills, medical reports and documentation, contracts and player agreements, personal accounts of the incident, witness testimony, photos and/or videos of the incident, first responder reports. Assumption of risk is a legal defense tactic in personal injury lawsuits. This legal doctrine prohibits plaintiffs from collecting damages when voluntarily participating in an activity they knew could cause injuries. Assumption of risk is usually outlined in waiver agreements or accepted by plaintiffs verbally. If a defendant attempts to argue assumption of risk, that does not mean that your case has no route forward. The burden of providing proof that you were aware of danger is on the defendant at that point. Every case is different. Talk to a TorHoerman attorney to gain more individualized insight for your claim.